3, 2, 1, start. He further argues that on the rudiments of the admitted facts that the air tickets of the petitioner were purchased by SML through its travel agent and that the payment of the tickets was made by SML, it stands established that the petitioner exposed himself to a pecuniary obligation. Stop. Furthermore, the petitioner was so desperate to attend the said seminar that he left station without making any prior application for leave and without availing prior permission from his superiors. Stop para. Drawing the attention of the court to page 111 of the writ application, he submits that the petitioner signed the attendance sheet in the seminar describing himself as an officer of WBSEDCL, though he stated in the proceedings that he attended the seminar in personal capacity. Stop para. According to him, the petitioner did not disclose as to where he stayed in New Delhi on 16th and 17th of April, 2008, though such fact was within his personal knowledge, and accordingly the inquiry officer rightly arrived at a finding to that effect that the petitioner availed hospitality of SML. Stop para. He further argues that the petitioner chose not to give any evidence and that as such the facts stated by him in reply to the charges do not stand established and that his witness was not an independent witness to whom any notice was sent by the inquiry officer on the application of the writ petitioner. Stop. Thus, DW1 was an interested witness and he was not given any evidence as to mode or manner of payment. Stop. No evidence for cash payment of price of ticket has been adduced and the bank statements or accounts of the petitioner were not disclosed to show withdrawal of any amount from the bank account of the petitioner. Stop. The books of account of SML was also not produced to show the actual date of payment, if any, and as to whether any money from the petitioner was recorded in the books of account of SML, and that the probative value of the evidence of the said witness was practically nil. Stop para. Replying to the argument of Mr. Chatterjee to the effect that the disciplinary authority had no jurisdiction to impose multiple punishments including withholding of pension and gratuity, Mr. Mitro submits that the concerned authority has such jurisdiction under the provisions of the West Bengal State Electricity Board employees within death cum retirement benefit regulations, 1985 within hereinafter referred to as the DCRB regulation to withhold pension and to forfeit gratuity as would be explicit from regulation 111A, and that the said service regulations do not exclude the operation of the DCRB regulation inasmuch as regulation 62 of the former starts with the clause within double quote without prejudice to the provisions of any law for the time being in force. Decode. Stop para. He argues that the scope of judicial review is very limited and in the event the inference drawn in the proceeding is supported by some materials on record, a court of judicial review will not interfere, and in support of such contention he relies upon the contents of paragraphs 12, 13 and 14 of Narinder Mohan Arya within Supra paragraph 44 of Rup Singh Negi within bracket Supra, paragraphs 6, 8 and 10 of Kuldeep Singh within bracket Supra, and paragraphs 15 and 19 of State of Uttaranchal within bracket Supra, being the judgments cited by Mr. Chatterjee. Stop. He further submits that the findings of the inquiry officer, the disciplinary authority and the appellate authority are not based on any suspicion or surmise, and the reasoning given by the appellate authority is sufficient, and in support of such argument he has placed reliance upon the judgment delivered in the case of chairman, disciplinary authority, Rani Lakshmi Bai Kshatriya Gramin Bank within bracket Supra. Stop. He further submits that all the judgments referred to by Mr. Chatterjee are distinguishable on facts. Stop para. In support of his arguments, Mr. Mitro has relied upon the judgment delivered in the case of Union of India and others versus P. Guneskaran, reported in AIR 2015 SC 545, wherein the Honorable Supreme Court has summarized the law pertaining to interference of writ court in disciplinary proceedings, and upon the judgment delivered in the case of Union of India versus P. Chandramouli, reported in 2003 within bracket 10 SCC 196, wherein the Honorable Court has observed that once the charge stands established, the quantum of punishment should not ordinarily be interfered with by the court. Stop para. I have heard the learned senior counsels appearing on behalf of the respective parties, and I have considered the materials on record. Stop.